Elections will come to order. The clerk will call the roll.
Chair Kane.
Present.
Vice Chair Gonzalez. Beckley. Busey. Clardy. Fierro. Jeton. Schofield. Swanson.
Here.
The quorum is present pursuant to Rule 4, Section 16A for the sole purpose of taking testimony. The chair lays out as pending business House Bill 4459. Swanson. Ms. Swanson, you've already laid this bill out. But we're laying out the committee substitute offered by Representative Swanson. And you've laid it out. We're now going to proceed to testimony. Chair calls Dan Chandler. Okay. On deck, it's going to be Gerald Welty, Cindy Phillips, and Eric Opiella. All right. Gerald Welty. I believe he's left. Cindy Phillips. Okay. She's passed. Johanna McCrary. Johanna McCrary. Pass as well. Okay. Eric Opiella. Last call. Matt Kuhns. Did I get that last name right?
Coons.
Coons.
Pretty close.
All right, I got you as Matt Coons here on behalf of ES&S, and you're against this bill. Is that correct?
Yes, sir.
Please proceed.
Thank you, Mr. Chairman and members. I just wanted to address a couple of points on this bill. The first one being Section 125.0071, where it talks about a voter essentially being able to undervote at any time on a voting machine and cast their vote. That's been a VVSG guideline to be able to review a ballot. We're okay with that. We'd suggest maybe something, changing the word must to may, just to increase competition in the state. But voters have always been able to undervote in an election in Texas, so that's not an issue.
My bill to give seniors a tax break.
Oh, good. I'm sorry. Page 4, line 21 through 24. Okay. And then the other point I wanted to talk about would be on page 3, lines 19 through 21. Beginning September 1st, 2021, all software and hardware used in the voting systems need to be manufactured, stored, and held in the United States and sold by a company who those following guidelines are fine. I don't know if you've all thought about this, maybe you have, but I wanted to point out 4 key points that I think every one of you should think about when voting on that particular item. First of all, what would happen in the state of Texas, to my understanding, and the Secretary of State I'm sure would be glad to answer questions on this, would essentially decertify all the current voting systems in Texas, even the new ones that counties have recently purchased in September of 2021. Mm-hmm. Hundreds of millions of dollars have been spent already for equipment that couldn't be used. Second thing it would do is it would force all of those counties, big and small, to use a regular paper hand-marked ballot and hand count. What you'd essentially be looking at is unofficial results 2 weeks and maybe even months following a major presidential election or general election.
Yes.
The third item would be, and one thing that I think is probably really important to the larger counties, it would eliminate the vote centers that these counties have developed to make it easier for people to vote. Because once you move away from a voting machine, you can't have vote centers anymore, and it would move everybody back to precinct voting.
Okay. Thank you. Real quick, let the record reflect that Representative Schofield and Representative Busey are now present. Thank you. Members, any questions for this witness? The chair recognizes Representative Swanson.
Yes. I do know that Senator Creighton made a change to try to accommodate some of the things that were unintended consequences from the bill, and we'd certainly be willing to look at that. We don't want to cause anybody to throw out millions of dollars of machines.
Sure.
Or we know that we don't necessarily have all the chips that we need to have made in Texas. So
Correct.
if you wouldn't mind just getting my office a list of the things that you were looking at and talking about, we have 2 or 3 other things, little things we want to fix
Sure.
on the bill, but do it very quickly. If you could get it over there today, that'd be great.
Okay, I'll do my best.
Thank you.
Thank you, folks. Appreciate it.
Yes, it's very close.
Chair goes up Susanna Carranza. Valerie DeBille. Andrew Eller. All right, I got you as Andrew Eller here on behalf of yourself, and you're for this bill. Is that correct?
Yes, that is correct. My name is Andrew Eller. I'm here on behalf of myself, and I am for the bill. I just had a couple of comments that deals mostly with Section 1 of the bill, which is Section 31.014 of the Election Code. And it mostly deals with the electronic poll books and the record that a judge would get from as an election judge. Our county has not provided any type of record to us where we used to get the combination forms of who had been entered in the poll books. Now we don't have that. You know, as part of the code that's currently there, and I actually spoke with the Secretary of State's office this morning, they're actually supposed to be providing an electronic copy of that, which our county did not. So I'd like to strengthen some type of language around that, that gets done. And then also, if there's not electronic, possibly a paper copy that is provided at the end of the day, because the only thing the section says is, and this is actually already in the code, produce an electronic copy of the list of voters who are accepted to vote for delivery to the election judge after the polls close. Well, how long after the polls close? I'd like to see some type of wording in there that says, you know, within 2 hours, or some method that we could see it pretty quickly. And then maybe another statement in there that says something about and or provides paper copies immediately after the polls close or upon polls closing, you know, that day, something along those lines, because that would really help me. You know, I'm very conscientious about the way I take care of those logs and those combination forms, and I do cross off at the very end of the form and say this was the end of my day. I sign it so somebody can't add to it, and that prevents somebody from coming along later and adding to the poll numbers, and then all of a sudden also adding ballots that go along with those extra those extra voters. So anything along those lines would help. So I am for the bill, but I think that's an enhancement that would really help us in this case. So what questions do you have for me?
Chair recognizes Representative Swanson.
Chairman, thank you. You bring up some legitimate points, and also if you can say, do they need to have it available also to the 2 precinct, like to both parties who may be having a precinct convention? If you could just find my office and write out what you want and get it over there today, that'd be great.
Yes, I can do that. And yeah, I do think both parties would need that. And actually this last election, because we didn't provide it, and I've already told the Secretary of State's office this, I actually, at the end of the day, took the combination forms with the stickers from the electronic poll book, and I copied them on my phone with the camera because there was no other way to get a copy. And I offered that to the alternate judge of the opposite party, and he said, no, I'll just, if you got them, that's fine, but if I ever need them, I'll get in contact with you. So, yeah, I maybe the language of both the judge and the alternate judge would be
Just
helpful.
drop off your wish list at my office, okay?
Yes, I will.
All right.
Thank you.
I guess talk to Ethan today.
Ethan?
Yes.
Okay.
Thank you.
Thank you.
That's all for our registered testimony. Is there anyone else who wishes to testify on, for, or against House Bill 4459? We can. The chair calls up Keith Ingram.
Keith Ingram, Director of the Elections Division, Texas Secretary of State, here on House Bill 4459.
The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Mr. Ingram, I just want trying to understand what this bill does. Will all of our current machines work under this bill?
Well, we contacted the Representative Swanson's office yesterday. We had some concern about number 10 here on page 2, or number 9, that because the way the internet works, you don't know really which node you're using on the internet for the fastest transfer, so it could be one in Oklahoma or Louisiana. And then what we're talking about, the data, this data here, is people who voted in the election. It's not the votes or anything to do with other than just the list of people who voted. This is sometimes temporarily stored in the Amazon cloud, and the Amazon cloud doesn't have any physical servers in Texas. So if we put this to the United States, then I think our publics meet this.
Okay, but right now, as written, it wouldn't do it.
I don't think so.
So what would be canceled out? All of our current machines?
All the current electronic poll books that
Yeah.
we use in the state.
Okay, I appreciate it. Thank you.
Thank you. Thank you, Mr. Ingram.
Thank y'all.
Is there anyone else who wishes to testify on for or against House Bill 4459? If not, the chair recognizes Representative Swanson to close on the bill.
Thank you, Chair Kane. Due to the late time in the session here, we may need to make some of these changes on the floor, but either way, please get me. I know we've talked to you guys, and we'll get it either amended now or on the floor. Thanks so much, and I close.
Thank you, Representative Swanson. If there is no objection, the committee substitute will be withdrawn and the bill will be left pending. Is there objection? Chair hears none. The committee substitute is withdrawn. The bill is left pending. The chair lays out House Bill 1892 and recognizes Representative Schofield to explain the bill.
Thank you, Mr. Chairman. Members, this is a simple one, kind of a common sense bill. The outside of the mail ballot envelope will often list the party in a primary election. Makes perfect sense. When they show up, you need to know which pile to put them in. There are, however, we've been getting reports in the last couple cycles, a few counties that have not been removing that the rest of the cycle. So when your mail ballot comes in a general election, or when it's in the mail or when it's anywhere, people can see which party it is that you're voting for, which, number one, compromises your secret ballot. It also gives people who don't like the way you're going the opportunity to throw your ballot away. In any event, that's not supposed to be happening. I called the Secretary of State's office and said, we don't think this is supposed to be happening, but it's not actually illegal. And so this bill would require that all the counties do what the vast majority are doing already, which is not put that on the outside of the envelope in any election other than the party primary, for which, of course, it is a good idea. I don't know if there are any witnesses, but Mr. Chairman, I would, if there are no questions, reserve my right to close.
Of course, we'll bring you back up. Let's check our witnesses. All right. Chair calls up Ben Brown. Ben Brown. Okay. Rose Clouston. Robert Green. All right. I sir got you as Robert Green. You're on behalf of the Travis County Republican Party Election Integrity Committee and yourself, and you're for this bill. Is that correct?
That is correct.
Please proceed.
Representative Schofield just stole my thunder. I had it written right on here.
All right.
It's just common sense.
Great. Thank you, sir.
All right.
Members, any questions?
Questions?
None. Thank you. Chair calls up Cindy Phillips. Johanna McCrary. Okay. Gerald Welty. Mr. Welty. Ben Brown, last call. Okay. Is there anyone else who wishes to testify on for or against House Bill 1892? If not, the chair recognizes Representative Schofield to close on the bill.
Thank you, Mr. Chairman. I'd appreciate everybody's support for this common sense bill, and I close.
Great. Thank you, Representative Schofield. Agree. If there is no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. The chair lays out House Bill 3556 and recognizes Representative Clardy to explain the bill.
Thank you, Mr. Chairman, members. This is a bill that came to me through my election administrator in Nacogdoches County, Todd Stallings, and it concerns the training of volunteer deputy registrars.
One moment, Representative Clardy, I think this is important. Let's back up. I need the record to reflect that Representative Clardy is not present. It was a good catch, right? So, yes, sir. Just real quick, we're just going to, now that it's proper, we'll lay that bill out again. Chair lays out House Bill 3556, recognizes Representative Clardy to explain his bill. Please proceed, sir.
Thank you, Chairman Kane and members. It's like deja vu all over again. This concerns volunteer deputy voter registrars, and this bill came to me through our election administrator in Nacogdoches County, Todd Stallings, who does a fantastic job. It's been noted that in certain counties, they've been using online training as an option for volunteer deputy registrars. However, we have some concerns that the VDR applicants can sign up for training even though they do not live in the county that offers the training. This leads to some concerns. Voter registrars in the county where the VDR, volunteer deputy registrar, resides must accept the VDR certificate from the county where they completed the certificate and may advise them on local procedures, but there's no mandatory local training. There's concerned parties that this is especially pertinent in towns like Nacogdoches, where there's college. It's a college town where you have some younger, less experienced people who want to participate as volunteer deputy registrars. It seems important, rather than having a one-size-fits-all training, that it's led by the person responsible for voter registration, who can make sure that what's being done is accurate and complete, so as they receive those voter registration cards from potential voters, that they're properly filled out so that they will have the opportunity to vote. And that's really the point of this bill. House Bill 3556 seeks to alleviate part of the problem by requiring in-person training of volunteer deputy voter registrars. This will be best done by the folks running those in each of the counties. I'll be happy to answer any questions you may have about this bill.
Members, any questions for the author? None. We're going to proceed to testimony. Chair calls Henry Bonnert, Susanna Carranza, Rose Clouston. Henry Bonnert, Susanna Carranza, or Rose Clouston. All right. Valerie DeBille, Johanna McCrary. Pass. Okay. Cindy Phillips, Fatima Menendez, Gretchen Nagy, Jen Ramos. All right. Howdy, Jen Ramos. We've got you here, Ms. Jen Ramos, got you here on behalf of the Texas. I got to what? Jen Ramos, here on behalf of the Texas Democrat Party and yourself, and you're against this bill. Is that correct?
That is correct.
Please proceed.
Thank you, Chairman and members of the Elections Committee. My name is Jen Ramos. I currently serve as a representative for the State Democratic Executive Committee for Senate District 21, which includes 18 counties from Southeast Travis all the way down to the border in Laredo, and I stand in opposition of House Bill 3556.
Ms. Ramos, it's really important because yes. I've got you signed up as being here on behalf of the Texas Democratic Party and yourself.
That's correct.
Okay.
I'm representing the Texas Democratic Party in my capacity as an SDC member.
Okay. Go ahead.
Yes, and I stand in opposition to this bill. This bill puts a prohibition on virtual trainings and makes it harder for people to register to vote. As you know, Texas has 254 counties, and we need as many VDRs as we possibly can. This bill would limit that by allowing for in-person trainings. In particular, this would affect rural counties, such as the ones in my district, because as it stands right now, the in-person training requirement would limit capacity for elections offices and would only allow for trainings to happen during the day in working hours, which not only diminishes the capacity for VDRs to be able to take those trainings, but it leaves out working class folks and people who have families who cannot attend these trainings during the day. In particular, Webb County, which is the anchor county in my district, happens to only have their trainings every other week at 3 p.m. This excludes the ability to have people attend their trainings. Furthermore, in a pandemic, it seems counterintuitive for us to minimize this and only allow for in-person training. I believe we should be able to hold this capacity. For example, people can take driver's license exams in other counties that they don't reside in. Why can't we do the same for VDRs? And furthermore, I would like to close and state my opposition for this bill.
Thank you, ma'am. I think you may have a question from a rural county member. Chair recognizes Representative Clardy.
Being here for your testimony, we get the microphone turned on, and I appreciate your concerns. And to be very clear, this was the original draft of the bill. We've had other matters. It would be my intention, should we get this to the floor, that there's not a desire to do away with online training from other sources. What really the purpose of the bill was, is not, that would be my intent, is to have that supplemented by that local registrar to make sure that those people who've been trained in Harris County or Travis County, online, wherever, when they come to do registration of votes in a particular county, this instance Nacogdoches or other rural counties, they have an opportunity, and the registrar of the voter registrar in the county can explain to them the particulars of that county, make them familiar so that he understands or she understands that this VDR, volunteer deputy registrar, knows the lay of the land, knows that when they go out, that they know what information is mandatory that must be filled in for that person to be registered. What we want to do is make sure that efforts to register voters is successful and that it comes back and is accepted. So we're not, the base training can be done online or remotely or in another location, but it's going to be more effective, in my opinion, that that they have that local contact with the voter registrar in that particular county. So I appreciate you make valid points, and I just want to tell you that.
Representative, if I may offer a counter suggestion. One thing that might actually help, and especially with the fiscal note in the state of Texas, is rather than have 254 counties with individual elections offices, if we did a statewide VDR program and have one universal training, that would save implications of the fiscal note and allow for universal training to meet those implications.
I appreciate that suggestion. I will just tell you I'm diametrically opposed to that idea. That's not the purpose of this bill. I think it's important we maintain the sanctity of our 254 counties and their uniqueness as they still exist. So, but I appreciate your perspective. But again, that's what this bill does. But I thank you for your testimony.
Thank you, Representative.
Thank you, Ms. Ramos. Thanks so much. Is there anyone else who wishes to testify on, for, or against House Bill 3556? If not, the chair recognizes Representative Clardy to close on the bill.
To you, wouldn't you?
All right. Thank you, Mr. Chairman. Members, you heard my explanation, Ms. Ramos. Again, I think this is a good local control bill. It makes sense. I think it's going to lead to more effective registration and able to have more people participate in the election process, and I would ask for your favorable consideration. With that, I close.
The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Representative Clardy, is this banning counties, this option? You just talked about local control. Is it banning their option to do virtual training?
No, and maybe you weren't paying rapt attention to my explanation to Ms. Ramos.
That was what you were saying you didn't want it to do. I'm asking, does this bill do that?
Oh, what the bill as currently drafted does that, but you know where we are in the process, and it's my intention and my representation to my members of this committee that should this bill be favorably received as we go forward, I will make sure that it contemplates and allows remote training. But again, I think it is important locally that there be input from the voter registrars in the counties.
So it's your intent to do a committee sub that allows for local counties to still do virtual, but you just don't want it to be one county to the next.
Right.
I appreciate it.
Right.
Thank you, sir.
And with that, Mr. Chairman, I close.
Thank you, Representative Clardy. If there is no objection, the bill would be left pending. Is there objection? The chair hears none, and the bill is left pending. Members, we're going to stand at ease for just a few moments here. Members, we're going to be voting on some bills. House Bill 3974 by Paul, 3269 by Noble, 1812 by Swanson, 3341 by Swanson, 2149 by Clardy, 4459 by Swanson, 1892 by Schofield, and 3556 by Representative Clardy. The chair lays out as pending business House Bill 3974. Members of the bill we heard previously relating to the residence address of a voter for purposes of a response to a confirmation notice sent by the voter registrar. Representative Schofield moves that House Bill 3974 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
3974.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 1 nay, the motion prevails. The chair lays out as pending business House Bill 3269. Members of the bill we previously heard relating to the requirement that a ballot to be voted by mail be canceled and returned before voting in person. Representative Swanson moves that House Bill 3269 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 1 nay, the motion prevails. The chair lays out as pending business House Bill 1812. Members of the bill we previously heard relating to filing fees for certain candidates for office in primary elections. Representative Swanson moves that House Bill 1812 without amendment be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 1 nay, the motion prevails. Chair lays out as pending business House Bill 3341. Members of the bill we heard previously relating to a pilot program for recording activity at a ballot counting station. Representative Swanson moves that House Bill 3341 without amendment be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 1 nay, the motion prevails. The chair lays out as pending business House Bill 2149. Members, this is the bill we previously heard relating to temporary branch polling places. Representative Clardy moves that House Bill 2149 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
Yes.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
There being 6 ayes.
Sorry.
Hold on 1 second. What was the number? I mean, I know.
Representative Swanson, we're voting on House Bill 2149.
2149. Okay, aye.
Thank you.
Thank you. There being 6 ayes, 0 nays, the motion prevails.
So do this one for Swanson first. And then here's the script. There is a stub. So, oh, wait, no. Sorry, swap it. That one for Swanson.
The chair lays out as pending business House Bill 4459 by Representative Swanson. Members, this is a bill we previously heard relating to voting system equipment and creating a criminal offense. Representative Swanson offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. Representative Jeton moves that House Bill 4459 as substituted be reported favorably to the full House with recommendation that do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield. Swanson.
Aye.
There being 5 ayes and 1 nay, the motion prevails. The chair lays out as pending business House Bill 1892 by Representative Schofield. Members, this is the bill we heard previously relating to the form of an official carrier envelope for certain ballots voted by mail. The chair moves that House Bill 1892 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
Yes.
Clardy. Fierro. Jeton. Schofield. Swanson.
There being 6 ayes, 0 nays, the motion prevails.
Justin. Hey, Justin.
All right, members, we're going to vote on the last one for this moment. It's House Bill 3556 by Representative Clardy, which is laid out. Chair lays out as pending business House Bill 3556 by Representative Clardy. Members, this is the bill we heard previously relating to the training of volunteer deputy voter registrars. Representative Clardy moves that House Bill 3556 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
No.
Clardy. Fierro. Jeton. Schofield. Swanson.
There being 5 ayes and 1 nay, the motion prevails. All right, members, I'm going to do one more. This is going to be House Bill 2859 by Representative Busey. The chair lays out as pending business House Bill 2859 by Representative Busey. Members, this is the bill we heard previously relating to the Secretary of State posting on the Secretary of State's internet website databases containing certain information about elections. Representative Busey offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. Representative Busey moves that House Bill 2859, as substituted, be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. Beckley. Busey.
Yes.
Clardy. Fierro. Jeton. Schofield. Swanson.
There being 6 ayes, 0 nays, the motion prevails. Okay, members, we're now going to move on to hearing Representative Jeton's House Bill 2320. The chair lays out House Bill 2320 and recognizes Representative Jeton to explain the bill.
Thank you, Chairman and members. I'm here to lay out House Bill 2320, which is relating to the criminal offense of pre-filling an application for a ballot by mail. Currently, political campaigns and third parties can send vote by mail applications to anyone with any amount pre-filled out. This is commonly done for those over 65 years old, as they are all eligible to vote by mail. This last year, it became evident that this can be abused as some pre-selected disability as a reason for voting by mail, even without knowing their eligibility. This causes confusion for the voter who may believe the official looking form has validated their eligibility for a ballot by mail. Unfortunately, this could be costly for an unknowing applicant who submits false information on an application for a ballot by mail. All other known voters' information can still be pre-filled out and witness and assistants are still allowed to help voters with the application to the extent a current law allows it. House Bill 2320 protects applicants of vote by mail by not allowing campaigns or third parties to send out applications with a reason for voting by mail pre-selected. At this time, I'm able to answer any questions. Otherwise, I reserve the right to close.
Thank you, Representative Jeton. We'll bring you back up after hearing testimony. But first, members, any questions for Representative Jeton? Hearing none, we're going to proceed to testimony. On deck will be Gerald Welty, Jen Ramos, and Cindy Phillips. Gerald Welty, Jen Ramos. All right, the chair calls up Jen Ramos. All right, I got you as Jen Ramos here on behalf of the Texas Democratic Party and yourself, and you're against this bill. Is that correct?
That is correct.
Please proceed.
Thank you, Representatives. I have an opposition to this bill because I feel that it actually makes things more difficult. As we understand, those that are automatically eligible to vote by mail are 65 and older, and they have difficulty as it is reading fine print. I just want to bring this up as an example. Have you ever helped somebody understand how to navigate through technology or read materials who's over 65? There is a visual element that tends to go into play, and I feel that this also sets that hindrance for those who are over 65. Furthermore, it also creates criminal penalties for volunteers who want to help those who are elderly fill out the applications, and the last thing we need is to criminalize those who want to help others. Furthermore, I think that this bill would charge organizations to really make sure that this is what the voter wants, and this also creates an undue burden. Therefore, I stand in opposition to this bill.
Thank you, members. Any questions for this witness? Thank you, Ms. Ramos.
Thank you.
The chair calls up Robert Green. No. Thank you, Mr. Green. I've got you as Robert L. Green here on behalf of the Travis County Republican Party Election Integrity Committee and yourself. And you're for this bill, is that correct?
That is correct.
Please proceed.
The problem only arises if you have someone completing part of an application prior to the submission, which information may or may not be accurate, valid for the particular person who is going to be voting. Now, this is in no way hinders someone who is qualified to assist the voter in voting, but I'd just like to say that I think it's a good bill, and that it will prevent or at least begin to minimize the availability and the pathway toward possibly fraudulent submitted ballots.
Great. Thank you, Mr. Green.
Any questions?
Thanks, sir. The chair calls up Joshua Houston. Ms. Houston, I got you here as Joshua Houston. You're the Advocacy Director of Texas Impact, and you're against this bill. Is that correct?
That's correct, sir.
Please proceed.
My name is Joshua Houston, Advocacy Director of Texas Impact. We are here respectfully opposed to House Bill 2320. We believe it is overly inclusive of behavior that should not be a crime. So Texas Impact's the membership organization for mainline Protestants, Jews, and Muslim denominations across the state. And both during the primary and general election, we had 25 local congregations undertake campaigns to get their parishioners 65 and older to vote by mail. We have no idea how many may have checked that 65 plus box for their parishioners. We do know that a number of these congregations did make copies on their Xerox machines because they couldn't get enough applications from the county or the Secretary of State's office. But if any did, we don't believe that such action should be criminal, much less a felony. We're aware, and we think that this, many of the fraudulent things people might be concerned about are already covered under Section 84.0041, the fraudulent use of an application. It is already a state jail felony for knowingly providing false information on an application or intentionally causing false information to be provided. Adding this, checking the box as an additional criminal offense creates a landmine for the innocent and can have a chilling effect on otherwise permissible civic engagement. People should be proud to vote, not be afraid to vote. We thank you for your time, and we look forward to working with you.
Members, any questions for this witness? No? Thank you, sir.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2320? There's someone coming? Yes. Okay. The chair calls up Johanna McCrary. All right, I've got you as Johanna McCrary. Here on behalf of yourself, and you're for this bill. Is that correct?
That's correct.
Please proceed.
Reason I'm for this bill is because I do believe that it.
I'm going to bring you right back up.
I do believe that it will help curtail fraudulent activity, and also I'm past 65, and I don't think it'll hinge people my age to have this. And I don't think it is going to hurt to deter it because it's a criminal action. If it isn't, I'm sure they can prove themselves they're not guilty of doing such things. So I'm for it. But age factor, I'm past 65. So I don't think that's a true statement. Any questions?
No, ma'am. Thank you.
Thank you.
Very kind. Chair calls up Dan Chandler. Chair calls up Dan Chandler. Thank you, sir. I've got you as Dan Chandler here on behalf of yourself, and you're for this bill. Is that correct?
I'm under the understanding that this would provide penalties for.
Real quick, this is really important. So I got to have you confirm that your name is Dan Chandler. You're here today on behalf of yourself, and you are for this bill.
Correct.
Okay, please proceed.
Okay, this is for penalties for voting irregularities with machines. Is that correct? It was your bill, or is it with the? All right, it's your bill, right?
No, so this is Representative Jeton's bill. The caption is relating to creating a criminal offense of pre-filling an application to vote by mail.
Of what now?
Of pre-filling, meaning writing it out and sending it out to somebody, putting information on an application to vote by mail before it gets to a potential applicant.
Okay, is this about the voting?
Yes, sir.
Okay. Well, here's what I have to say about this. Okay, the democracy is the hallmark of this country. It is the very essence. It's the fabric of America. I'm astounded that we would compromise that in any way whatsoever. Anyway, that we would let people vote from Bangladesh or Mexico or anywhere else, that there would be voting machine irregularities, that we would not absolutely ensure that that process was not compromised. Anything we can do. And I think it's astounding that we would not be furious that we would have cancel culture, that you would try to destroy America, the very fabric of America, by compromising the voting system. That's literally what it is. And these guys can laugh and whatnot.
So, Mr. Chandler, is your position that the government should not pre-fill an application to vote by mail and send it out to people?
That's right. Okay. We're good. We should have no voting by mail. People should show up and have a voter ID. We should be able to absolutely confirm that whomever is voting is absolutely on the voter rolls, has the right to vote, is an American citizen.
Okay.
And you cannot do that with ballot voting. It's insane, and it's just rife with fraud.
Okay. Well, thank you, Mr. Chandler. Members, any questions? Thanks so much for coming into your Capitol. We appreciate your testimony. Okay. Is there anyone else who wishes to testify on, for, or against House Bill 2320? If not, the chair recognizes Representative Jeton to close on the bill.
Thank you, Chairman. I just want to point out that I think those our seniors over 65, I do believe in their ability to read or find someone to assist them with the ballot for a ballot by mail. And so I just urge everybody to vote favorably for this, and I close. There's no questions.
Thank you, Representative Jeton. Members, any questions for the author? Hearing none. If there's no objection, the bill will be left pending. Is there objection? The chair hears none, and the bill is left pending. All right, members, before going on to hearing some more bills, we're going to take up a few bills. We're going to take up House Bill 2320 by Jeton, which we just heard, House Bill 3281 by Representative Paul from earlier, House Bill 2339 by Representative Click, and we need to inform our friends of that in a moment, House Bill 3491 by Parker. So we're going to take a second.
Mr. Chairman, would you own those bills? Because
well, real quick, will the record reflect that Representative Beckley is present and Vice Chair Gonzalez is present?
On the bills that you named, Mr. Chairman, as you call those, would you read the caption of the bill?
I will, certainly.
Okay, thank you.
Representative Clardy, you asking me to do that now as a heads up? Yes, I will, of course. Okay, as a reminder, it's going to be House Bill 2320 by Jeton, which we just heard, House Bill 3281 by Representative Paul with committee substitute, House Bill 2339 by Representative Click from earlier, and House Bill 3491 by Representative Parker. The chair lays out as pending business House Bill 2320 by Representative Jeton. Members, this is the bill we heard previously relating to creating the criminal offense of pre-filling application for a ballot to be voted by mail. Representative Jeton offers up a committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. Representative Jeton moves that House Bill. Yeah. Start that back over. Members, there was no committee sub on that. All right. The chair lays out as pending business House Bill 2320 by Representative Jeton. Members, this is the bill we heard previously relating to creating the criminal offense of pre-filling an application for a ballot to be voted by mail. Representative Jeton moves that House Bill 2320 without amendment be reported favorably to the full House with recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey. Clardy. Fierro, Jeton, Schofield,
Aye.
Swanson.
Aye.
There being 5 ayes and 3 nays, the motion prevails. Our members are going to take up House Bill 2339 by Representative Click. The chair lays out as pending business House Bill 2339 by Representative Click. Relating to, it's a bill we heard earlier, relating to the use of information from the list of non-citizens and non-residents excused or disqualified from jury service. Representative Jeton moves that House Bill 2339 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey.
No.
Clardy. Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 3 nays, the motion prevails. All right, now we're going to move on to House Bill 3491 by Representative Parker. The chair lays out as pending business House Bill 3491 by Representative Parker. Members, this is the bill we heard previously relating to the security of electronic voting system media. Is there objection? The chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 3491, as substituted, be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
Nay.
Beckley.
No.
Busey.
Yes.
Clardy.
Aye.
Fierro. Chetan.
Aye.
Schofield.
Aye.
Swanson.
There being 6 ayes, 2 nays, the motion prevails. Okay, members are going to go back into hearing bills. Chair lays out House Bill 4322 and recognizes Representative Chetan to explain the bill.
Thank you, Chairman and members. Here to lay out House Bill 4322, which is relating to the locations of a polling place. House Bill 4322 confirms that polling places will be inside a permanent building and cannot be located in a tent, temporary structure, movable structure, parking garage, parking lot facilities, primarily designed for motor vehicles or personal residence. After discussions with several stakeholders, a committee substitute will allow for personal residences. In the instance, no other permanent building is available that meets ADA or other regular statutory requirements. House Bill 4322 was created after multiple discussions with concerned constituents about the integrity of elections and the location of polling sites. House Bill 4322 pushes us closer to having a more safe and fair election by codifying where polling locations can and cannot be located regarding physical buildings. I'm happy to answer any questions. Otherwise, I reserve the right to close.
Members, are there any questions for Representative Chetan? If not, we'll proceed to testimony. Chair calls up David Weinberg. All right, sir, I have you here as David Weinberg, voting rights advisor for the Brennan Center for Justice, and you're against this bill. Is that correct?
That is correct.
Please proceed.
Thank you, Chairman, members, and this young gentleman. Pleasure to talk to you today. We've got 2 concerns with this bill. First of all, and I'm sure this is not the first time this has happened in the history of the Texas legislature, but this bill appears to be going sort of in a different direction than a bill that was passed just a few minutes ago by Representative Clardy, which would bring back some form of temporary voting during early voting. And I know that some counties, when they would do that, would use mobile polling places. Like I would used to vote at a trailer at my HEB, and it was very convenient. There were Democrats and Republicans who worked there who were very nice, and I do not think it was a hotbed of voter fraud or any other mischievous activity. But today we're hearing a bill that says, sorry, no mobile structures, you can't do that anymore. So on the one hand, we're allowing counties maybe to go back to doing some temporary voting during early voting, but then taking away some mechanisms for how they could do that effectively. I think the second piece I want to emphasize with this bill is about the drive-through voting that was implemented in some Texas counties last year. And I think we've heard some testimony this session that this is not expressly permitted in code, and that there may be some other problems with it. But I think it bears mentioning, just to be extremely clear, I think counties were doing this to try to keep voters safe. Nearly 50,000 Texans have died from the COVID-19 virus. Thousands of Texans remain hospitalized from COVID-19. Just checking the numbers yesterday, over 100 new admissions for COVID patients to hospitals in Texas for COVID-19. Drive-through voting is something that counties were doing to try to keep people alive. I passed out an article. We had a poll worker here in Travis County, 70-year-old grandmother, pass away last fall who may have contracted COVID-19 while working at an early polling place. This is not a joke. If we want to improve upon drive-through voting during this pandemic, let's do that. But it seems like right now, it would be a bit premature to eliminate something that is meant to keep voters safe from this deadly virus. Thank you.
Thank you, sir. Members, any questions? Thank you. Chair now calls Rose Cluston, Susanna Carranza. Chair calls Chris Davis, Valerie DeBille, Hey there, I've got you as Valerie DeBille. You're here on behalf of the League of Women Voters of Texas and yourself, and you're against this bill. Is that correct?
That is correct.
Please proceed.
I'm Valerie Merriam DeBille, testifying as a member and on behalf of the League of Women Voters of Texas in opposition to HB 4322. We appreciate the opportunity to offer this testimony to you today. Thank you for allowing us to share the League of Women Voters of Texas position on this bill. The League of Women Voters of Texas opposes HB 4322 because it prevents election officials from responding to emergency situations where regular polling places are damaged or otherwise unavailable due to flooding, power outages, and other physical conditions. The threat to voting is real. As an example, Hurricane Zeta struck Louisiana and several other states on October 29th, 2020. Just a few days before the 2020 election day. Election officials had to scramble to assess the damage and set up temporary polling locations if needed. Tying the hands of officials during disasters makes no sense and is a cruel disenfranchisement of those who are doing what they can to vote even while dealing with a terrible situation. There were 30 named storms last hurricane season, and that is just one of many disasters, both natural and man-made, that can severely damage large areas and prevent the use of multiple polling locations in the region. We believe election officials should have the flexibility to deal with emergency situations and serve the voters of their areas as they deem necessary to safely provide eligible voters with the opportunity to cast their vote.
Thank you, ma'am. Any questions for this witness? The chair recognizes Representative Jeton.
Yeah, I just want to thank you for your testimony. When it comes to emergency situations, that is something that we went ahead and we talked to the SOS about, and we did want to make sure that we had something in there. And I believe emergency declarations do allow for some modifications to be able to accommodate voting still. If a floor amendment or anything is necessary to codify that, we'll do that. That's not the intentions. We do want to make sure that in those type of situations.
There's another bill, the number I don't remember, that actually wanted to strip the ability of any authority, any elected official from making changes to voting law.
Sure.
I'm not sure what the status of that is, but there's obviously an attempt at some point.
Yeah, emergency declarations usually have a whole different category for what they're able to do.
Well, my hope is that whatever we pass does not have an exception for emergency declarations. The legislature writes bills and writes the laws, and no one should be able to adjust them or suspend them or modify them. But anyways, members, any other questions for this witness? Thank you, ma'am. Chair calls up Henry Bonner, Johanna McCrary, okay, Cindy Phillips. All right. Chair calls Jen Ramos. Hi, ma'am. Okay, it's Jen Ramos here on behalf of the Texas Democratic Party and yourself, and you're against this bill. Is that correct?
Yes, that's correct.
Please proceed.
Thank you, Representatives. A data analysis by the Texas Civil Rights Project found that while non-white voters make up, give or take, about 38% of all Harris County early voters, they made up 54% of voters who use a drive-through polling location. This legislation would hinder our communities of color and not allow them the flexibility to continue to vote. Furthermore, it specifically seems to be a response and a target for the drive-through voting centers used in Harris County during the 2020 general election. And so, furthermore, I feel that this bill, as it's written, would also inhibit an election clerk's ability to creatively manage long lines or provide additional space at high traffic locations. This bill does nothing to improve election integrity. The rules are still the rules in drive-through polling places. Regardless if voting is being conducted in a parking garage or a library, polling places must still abide by the election code, and this bill wouldn't help make our elections more secure. Therefore, I stand in opposition to House Bill 4322.
Thank you, ma'am. Members, any questions for this witness? Thank you, Ms. Ramos.
Thank you.
Chair goes up James Slattery. Good afternoon. I've got you as James Slattery, Senior Staff Attorney for the Texas Civil Rights Project. You're against this bill, is that correct?
That's right.
Please proceed.
I feel like everyone is foreshadowing my testimony. Building suspense, I guess. This would impose a one-size-fits-all rule from the Capitol here in Austin on all counties in Texas. They cannot conduct what is known as drive-through voting. Drive-through voting was a wildly popular option at some polling places last year. Adopted as a vital safety measure during the pandemic, which continues to rage to this very day. It is hard enough to vote in Texas during normal times, but it was especially difficult to vote in Texas safely during the pandemic, given that the state remained one of only 6 states refusing to expand mail-in voting during the coronavirus pandemic. It is unbelievable then that the state might adopt a bill such as this that would make voting even less safe during the very same pandemic that we are still living through, not to mention future crises. Further, the burden of taking away drive-through voting won't fall on all voters equally. Eliminating drive-through voting would disproportionately harm communities of color. TCRP conducted an analysis with TargetSmart of the voters who used drive-through voting and found that drive-through voting was more likely to be used by people of color than early voters as a whole. That is not surprising, given that people of color have been disproportionately more likely to be infected with the coronavirus and die from it than white Texans. As such, taking away drive-through voting would in particular have a disparate impact on people of color seeking a safe way to vote. We therefore urge the committee not to vote this bill favorably.
Thank you, Mr. Slattery. Mr. Slattery, you mentioned that the state of Texas refused to expand mail-in balloting to everybody. Is that correct? How could we have done that if the legislature wasn't in session?
Well, the governor issued a series of emergency orders making changes to election laws. So, you know, in theory, if he did have the authority to do what he did, then he could have expanded vote by mail to all Texans. He could have allowed Texans to register to vote online. He could have taken a number of actions.
Okay. Thank you, Mr. Slattery. Members, any questions? Chair recognizes Representative Beckley.
So do you think this bill is just another bill that's looking for a problem that doesn't exist?
Yeah, I'm not sure that voter fraud or other threats to voting are more likely to take place in tents than elsewhere.
And do you think that it can't be like a temporary building as well? Like, so if somebody was to use a trailer, you know, sometimes schools have temporary buildings. Is that excluded in your interpretation of this bill?
I'd have to look again, but I think, you know, you raise an important point. So the bill talks about parking garage, parking lots, similar facilities primarily designed for motor vehicles. So I'd have to think about that. But I think the point being that this is a very big state with 254 counties, with people living in a number of different urban or rural environments, and that really like letting counties determine options like that based on their unique circumstances is vital.
Well, I could even think in a rural county, like, you know, where they needed to go by horseback, that they might want to go do a tent revival voting on Polls to the Souls. I'm just going to say that might be something in there, and now they can't.
Barn through voting, if you will.
Members, any other questions for this witness? Being none, thank you.
Thank you.
Mr. Chairman? I haven't been to my optometrist recently. I may be seeing double. How many canes are on the podium today?
There's two. There's two Briscoe canes here. One's just a little, one's taller than me, like that one. Thank you. The chair calls up Don Garner. Russell Schaffner. Mr. Schaffner, I've got you as the Assistant County Administrator for Tarrant County, and you were here to testify on this bill. Is that correct?
Yes, sir.
Okay.
And also, Mr. Chairman, if you would strike my previous registration as I dropped a card against to begin with, but in conversations with Representative Chatan.
Okay, one moment. We're going to repeat these questions. So let's talk to the clerk. I believe Mr. Schaffner's here. He's testifying on, but I believe he may have done a registration without testifying to be against it, and he's requesting that we correct that.
We're good. Thank you very much.
Members, any questions for Mr. Schaffner?
Real quickly.
Please proceed.
Mr. Chairman, wanted to say thank you for hearing this bill and for Representative Chachan working with us. Our concern doesn't have to do with drive-through voting. Our concern has to do with rats. So in 2018, we had an election. One of our polling location, whenever the election workers went in, it turns out that there were rats all over the place. And we could not, in good conscience, ask people to come in and vote in a polling location that had rats in them. So because our elections administrator and elections team had the foresight to what do we do if we have an emergency, they had a trailer that had some polling equipment in it and put up a tent in the parking lot. And we had under a tent voting, again, with a trailer. They referred to it as the hot dog stand. My elections administrator was particularly proud and sent pictures if y'all would like to see them. But the ability to respond to an emergency situation that, if you will, an act of God, whether it be rats, a broken pipe, some bizarre situation that does occur, our ability to respond to that and make sure that folks that believe that they could wake up that morning or that evening and go to that polling place could be served. And sent some policy proposals over to the representative's office that, again, it would have to be at a polling location that the Commissioner's Court did approve, that there had to be some unforeseen circumstance involved, again, rats or broken pipe. And then third, that there would be a policy in place on how we would respond to this situation. So those are our comments, and happy to answer any questions.
Members, any questions? The chair recognizes Representative Clardy.
Thank you, Chairman. And Mr. Schaffner, if I think I understood you correctly, the issues you went through, emergency situation or other exigencies which necessitate moving a location, you've addressed that with Mr. Chachan and provided some
yes, sir.
proposed language to that effect. And I'll ask him on his closing, but it sounds like that was favorably received by Mr. Chachan, and we're considering because that's really my concern with the bill too. You know, how do you define? I mean, I'm thinking of specific voting locations in my district that are in their permanent locations, but they would be properly defined as portable buildings. They're not really, they're not on, you know, they're not on a pier and beam. They're not on a foundation. It just depends on where they are. One of the counties has a number of small little wooden shacks which serve as the voting location in those smaller precincts. So, you know, I wouldn't want to have those excluded operation of law, but if Mr. Chachan has been talking to you about how to work around that, I appreciate that. So I'll address that with him on the close, but thank you.
Thank you, sir.
Members, any other questions for this witness? Thank you, Mr. Schaffner. Chair calls Keith Ingram.
Good afternoon. Keith Ingram, Director of the Elections Division, Texas Secretary of State, here on House Bill 4322.
Okay. Chair recognizes Representative Busey.
Thank you, Mr. Chairman. Mr. Ingram, how are you, sir?
I'm fine.
Do you know the list of counties that use drive-through voting?
I do not.
Was it more than one county that used drive-through voting?
I know it happened in Harris County. I'm not aware of it happening elsewhere. I think some other counties had 24-hour voting.
I think I have notes here that we did have it elsewhere. B County. B County, you familiar with that, Clardy? Use drive-through voting. Let me ask you, sir, just to get to the point. Not B County. Does a voting machine work differently if it's indoors in a pier and beam building, or if it's in a weatherproof tent, or if it's in another mobile vehicle? Does the machine function less safely?
Well, it kind of depends on the voting system. The HART E-slate systems that they used in Harris County had to be disconnected from the JBCs in order to go out to the car, and then has to be resynced to the JBC. And so that was something that wasn't occurring every time they went out to a car on the drive-through voting. And so it did cause a discrepancy in the vote totals on the machines versus on the JBCs.
Did that mess up the vote results?
It took some effort to reconcile in front of poll watchers and everyone.
I guess my question is, if we're going to be set up under a circus tent, or if we're going to be set up in a library and we can plug in, is there an issue?
There shouldn't be an issue with the equipment if it's plugged in and stationary and just like a regular polling place. I will mention, since Beeville came up, that in B County in 2012, there was a situation where the polling place was infested with bees. And so they called us and said, what do we do? And we said, we'll vote everybody curbside. And she said, don't worry, I've already called the funeral home. And why have you called the funeral home? Well, because they've got tents. And so she was going to set up a tent in the parking lot.
They set up tents, and it saved the election for the people of Texas. Thank you, sir.
For Peake County.
Thank you. Members, any other questions? The chair recognizes Representative Clardy.
Just to be clear, Mr. Ingram, at the funeral home, they weren't trying to register new voters at the funeral home.
They were not, no.
Thank you.
Though that's the seed of an idea there.
Yes. Thank you. Thanks, sir. Is there anyone else who wishes to testify on, for, or against House Bill 4322? If not, the chair recognizes Representative Juton to close on the bill.
Thank you, Chair. I know you have a question. There's a few things that were kind of brought up after we've, and that we want to try and either get in a committee sub or we can do floor amendments. But one of them was the need in some areas for a residence because there were no other physical structures available that met the ADA requirements. And so in those situations, there would be an exception. And then additionally, emergency situations where the notice has already been sent out that this location is a polling location. And once it's noticed, I think it's right at that point to find some way to make sure that they have a way to still conduct that election at that location. That the primary goal of the bill is to make sure that the polling equipment and everything is within a solid structure, and that helps secure it while the election is going on during the day, but also helps us make sure it's secure at night without everything having to be removed or additional security having to monitor that location with a soft structure. And so that's the main intent of the bill. Willing to answer any other questions anybody may have. Otherwise, I close.
Thank you, members. Any questions for the author? Thank you, Representative Juton. If there's no objection, the bill would be left pending. Is there objection? Chair hears none, and the bill is left pending. Real quick, the chair lays out House Bill 3645. Chairman Kane's going to go and explain the bill. Members, Vice Chair Gonzalez, members, thank you for allowing me to lay out this bill today. Texas currently prohibits a person from knowingly voting or attempting to vote more than once in an election. However, Texas has no law banning someone from voting in Texas after voting in another state in an election in which federal office appears on the ballot. House Bill 3645 makes it an offense to vote or attempt to vote in a Texas election that is a federal office on the ballot after voting in another state. If there are no questions from the audience, I'll close after hearing from witnesses. Members, are there any questions? Okay, the chair calls up Gerald Welty. Chair calls Cindy Phillips. Okay. Johanna McCrary. Okay. Members, would you like to hear from the Secretary of State? Anybody? Okay. Is there anyone else who wishes to testify on, for, or against House Bill 3645? If not, I'll close on the bill. Okay, members. I think it's a simple bill. If you've looked at it, we're just kind of clarifying that you cannot knowingly vote or attempt to vote in an election in this state after voting in another state in an election in which a federal office appears on the ballot, and the election day for both states is the same day. With that, I close. If there is no objection, the bill will be left pending. Is there objection? Hearing none, the bill is left pending. We'll move on to House Bill 4364 by Juton. Chair lays out House Bill 4364 and recognizes Representative Jeton to explain the bill.
Thank you, Chairman and members. I'm here to lay out House Bill 4364 relating to poll watchers and creating a criminal offense. What this bill focuses on are concerns and real-life examples of watchers simply not being allowed to observe even after they are legally appointed. Poll watchers are regulated by Chapter 33 of the Election Code and appointed by candidates or parties. Candidates or parties get only 2 watchers per location. So they get certificate of appointment that they give to the presiding judge, and then are part of the democratic process. HB 4364 adds a simple requirement where poll watchers must present proof of identification to the election judge so that the judges can verify the poll watcher's certificate. This bill also prohibits judge from flat out not accepting the poll watchers from campaigns or parties. Specifically, we're talking about accepting the poll watcher. Chapter 33 and its subchapters still apply. A judge can still refuse a third watcher who shows up or a watcher with an active camera. Another thing House Bill 4364 does is allow poll watchers free movement in the locations they are at. This goes along with current law in 33.056, where they are entitled to observe and be near enough activity in the polling locations. Poll watchers are still required to follow 33.057, where they cannot be present at a voting station where a voter is voting or being assisted, and 33.058, where they cannot talk or communicate with voters. Finally, House Bill 4364 allows poll watchers to observe the sealing and transfer of electronic mediums like hard drives, flash drives, memory cards, or anything dealing with the voting system equipment. We've heard a lot about poll watchers in this committee, primarily concerns about ensuring watchers cannot obstruct or harass voters. House Bill 4364 leaves intact current law that prohibits that from happening today. When we say we want free, fair, and transparent elections, it is the poll watcher who is the third leg of the triad, along with the election judge and the clerks. At this time, I'm happy to answer any questions. Otherwise, I reserve the right to close.
Members, any questions for Representative Jeton? Okay. The chair recognizes Representative Clardy.
Thank you, Mr. Chairman. Representative Jeton, in your layout, you mentioned something about, I didn't quite catch it, but where poll watchers were talking, were able to communicate. I didn't.
Yeah, so poll watchers are still not allowed to communicate with voters, and they are still not allowed to be in the voting stations where voting is occurring or there's someone's receiving assistance.
All right. I want to make sure I heard that the right way. Thank you.
Yeah, Representative Jeton, I believe currently under Chapter 33, a poll watcher is not allowed to talk to a voter, period. So I know some people are concerned about harassment. They're not even allowed to talk to a voter. And outside of calling the attention to potential irregularity, which the code addresses, they can't talk to election workers either. Is that correct?
That's correct.
Okay. Thanks, sir. Members, any other questions? Now we're going to proceed to testimony. Chair calls up Jen Ramos. Eric Obiella. Fatima Menendez. Okay. Valerie DeBille. All right, I got you here. It's Valerie DeBille, on behalf of the League of Women Voters of Texas and yourself, and you're against this bill. Is that correct?
Correct.
Please proceed.
I'm Valerie Merriam DeBille, testifying as a member and on behalf of the League of Women Voters of Texas in opposition to HB 4364. We appreciate the opportunity to offer this testimony to you today. Thank you for allowing us to share the League of Women Voters' position on this bill. The League of Women Voters of Texas opposes HB 4364. It may be well-intentioned, yet it creates the potential for more problems than it would solve. As such, it is an unnecessary addition to election procedures already in place. The bill, similarly to HB 2602 and other bills being considered, allows poll watchers to come and go at will in and out of a polling place while voting is taking place. This provision would call for the election judge to monitor the watchers' movements and whereabouts in the polling place, as well as interacting with the voters, workers, technicians, and other authorized persons. This would distract the election judge and clerks who should be devoting their time and attention to their own tasks. Poll watcher actions could impair the election workers' ability to focus on the several duties and reporting responsibilities assigned that must be handled properly and in a timely manner. Creating a Class A misdemeanor for rejecting a poll watcher places election officers in the untenable position of being arrested and held in county jail and then forced to defend their actions at their own expense after having done what they understood to be the correct way to preserve the integrity and order of the voting site. If there are concerns about an election officer improperly rejecting a poll watcher, another way to manage these issues would be for the Secretary of State to address them administratively rather than charge an election official with a crime. We appreciate your attention to our position and urge you to vote against the passage of HB 4364.
Members, any questions for this witness? Hearing none, thank you. So much. Chair calls up Rose Clouston. All right, I see you here registered. Looking for my screen.
As you can guess, against the bill.
Rose Clouston, Voter Protection Director for the Texas Democratic Party, and you're against the bill, is that correct?
That is correct, yes.
Thank you.
As we discussed with the committee when we talked about House Bill 6, we have the same concerns about this bill in terms of poll watchers. And I say this from the knowing position of having trained and managed hundreds of poll watchers this fall. This bill is unnecessary and, in fact, is only going to serve to deplete our resources of presiding judges and election workers because of the criminalization of their work. Many election workers will be doing their best and trying to keep peace and keep their polling place running smoothly and need to remove a poll watcher or need to constrain their movement in some way to keep things flowing. And by criminalizing them, you are only serving to intimidate the poll watcher, the poll worker, and prevent them from running their polling place, as Valerie shared about in League of Women Voters testimony. Additionally, you heard from Linda Lewis with the NAACP of Texas in the House Bill 6 testimony about a very specific instance in Waco that happened this past election where that exact thing happened. And a poll worker, a longstanding election judge who is very conscientious and does her work very well and takes pride in how she runs her polling place, had to remove a poll watcher for being inappropriate in her polling place, and then they tried to retaliate and remove her as a presiding judge. This was found to be unfounded, and this was dropped, but took time away from her and discouraged her and others around her from continuing to serve as poll workers. You will only have this repeat itself across the state if this bill goes into effect, and fewer people serving as election judges, even longstanding folks, as you criminalize their behavior and them just trying to do a good job. Additionally, yes, the identification provision seems unnecessary as well. Any question? Happy to answer any questions.
Great. Real quick, Ms. Clouston, you're concerned about the election judges being discouraged. Are we not concerned about watchers being discouraged if they can just be excluded for any reason and they have no recourse?
An election judge and a poll worker is an essential part of the voting process. Every polling place in this state needs to have at least 3 poll workers. A poll watcher is an optional part of the process. So I am much more worried about not having enough workers to staff all of our polling places across the state, as is often the case where we are scrambling to find those workers and have to close polling places, than I am about not having poll watchers who may or may not, who are an optional part of the process.
Okay, thank you, ma'am. The chair recognizes Representative Beckley.
So it seems that there's a little bit of tense situation between election workers and poll workers.
Sure.
Can you see, like, now that they can bring their guns in there, that this could be a problem as well?
Yes, absolutely. When we were hearing that bill debated on the floor, I was recalling Chairman Kane's own words from that conversation about House Bill 6, where he was saying that there is that inherent tension that you're raising between these folks and the intimidation factor between either an election judge, a presiding judge and an alternate judge, or the intimidation factor of a presiding judge and other folks in the polling place. Absolutely.
So a judge can actually be intimidating to a poll watcher in that situation?
Absolutely.
Thank you.
Thank you, members. Any other questions? None? Thank you, Ms. Clouston.
Thank you.
Members, you wanted to hear from the Secretary of State's office? Usually, that's what Representative Specie wants. The chair calls up Christina Atkins.
Good afternoon, Christina Adkins with the Secretary of State's Office on HB 4364.
Chair recognizes Representative Busey.
Thank you, Mr. Chairman. Ms. Adkins, I'm trying to think about the intersection of this bill and House Bill 6 and what free movement is going to mean when you can no longer remove someone in House Bill 6. So I'm just, can you explain what the restrictions will be here versus what won't if both those bills pass through this legislative body?
So with the bill that we're talking about today, HB 4364, I mean, I would read free movement to be that that person has access to all of the activities and events that are occurring in the designated location. So if it's signature verification committee, if it's a polling place, if it's central count, that they have movement within the defined area that constitutes that, whatever that event is, to see the activities that occur that pertain to that particular theme. So I would say that there might be a limitation in that, for example, with the central counting station, only the part of the building that's designated for use of central count, you know, a poll watcher would be allowed free movement within that area, but it wouldn't extend to maybe other parts of the election office.
What are sensitive, is there any sensitive material? We already say they can't go look at the voting machine, right? Like as you're voting.
As a person's voting, correct.
Is there other sensitive material that they're not allowed to see under current law? Check-in information, private information, anything?
I think that the law currently allows for poll watchers to be able to review records that are in a polling location or records that are relevant to whatever it is that they're observing. So they do have access to those election records, and they should be able to view them and observe them.
So if they have free movement, they can go see anything going on whatsoever, personal data, all that is available.
That's correct.
Now,
as long as it pertains to the election.
All right.
Yeah.
Which, I mean, some of these bills, we're going to have photos of your body to get to vote. What about, the author said it wasn't his intent. I mean, they could still have restrictions based on you can't talk to a voter. So under the bills we've got moving in this bill, could you remove someone that's talking to a voter? If this and the intersection of House Bill 6 happen together?
So currently the law says that a poll watcher cannot converse with a voter. So that's current law as it is. I think when you're asking about some of the other bills that are out there with respect to poll watcher rights and how an election judge can interact with a poll watcher, there's one provision of the code, 32.075, that talks about the duties of a presiding judge. I will say, I think that we probably need to look really closely at any modifications we make to that provision specifically, because that's where the presiding judge has authority to either remove somebody or direct somebody, maybe bring in law enforcement to direct them to remove somebody if that's the direction that we need to go. And we just need to be real careful about what changes are made to that provision, because that's where the inherent authority of the presiding judge comes from to take actions when you have a poll watcher that, you know, appropriately needs to be addressed.
But this bill doesn't do anything to 32.075.
That's correct.
Yeah, I'm just wondering about the intersection of this bill and other bills that we've already passed out as committee. I appreciate it. Thank you, Ms. Atkins.
Sure.
Members, any other questions? Thank you, Ms. Atkins.
Thank you.
Is there anyone else who wishes to testify on for, okay, come on up, Mr. Robert Green. All right, I got you as Robert L. Green here on behalf of the Travis County Republican Party Election Integrity Committee and yourself, and you're for this bill, is that correct?
That is correct, Mr. Chairman. I don't get upset too often about testimony that's been given, but we have heard before this committee and before several Senate committees about abuse of poll watchers at specifically central count. We don't see too many problems at polling places themselves, but at central count, abuse by election officials of poll watchers, preventing them from seeing any aspect of the process which they are entitled to do under the law. So yes, I am in favor of this. And there should be an offense. Without punishment for violations, what good is any law? We've got a situation here. An election officer commits an offense if the officer intentionally or knowingly refuses to accept a watcher for service when acceptance of the watcher is required by this section. An offense under this section is a Class A misdemeanor. That, in and of itself, should discourage an election official for just saying, well, I don't want the watcher around. I don't want this watcher to be able to see what we're doing here, and then try to remove them. We go on down here. If you deny the watcher free movement around the facility, specifically again in central count, they are entitled to do that. They are entitled to observe. We're not talking about situations where a watcher goes up and looks over the voter's shoulder at a polling place. We know that's improper, but I'm far more concerned about what happens at the central counting location, and that they kick out or try to kick out a poll watcher. They haven't done anything wrong.
Members, any questions for this witness? None? Thank you, Mr. Green.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 4364? If not, the chair recognizes Representative Jeton to close on the bill.
Thank you, Chair. I appreciate the testimony. Available to answer any other questions, otherwise I close.
Members, any questions for the author? Hearing none, thank you, Representative Jeton. If there is no objection, the bill will be left pending. Is there objection? The chair hears none, and the bill is left pending. Chair now lays out House Bill 4028 by Representative Kane. This bill, members, thank you, Vice Chair Gonzalez, members, for letting me lay this bill out. House Bill 4028 is about election integrity, but more specifically, it's to ensure that the people in charge of running the elections are properly trained. Texas Secretary of State currently offers training to election judges and clerks. This bill will simply extend that training to whoever the county's designated election officer is, as the county election officer is currently not required to complete any training. This bill is the companion bill to Senate Bill 231 by Senator Seliger. It's a small bill, but a bill that I think will help in our effort to rebuild voter trust. I believe the Texas Secretary of State's office is also here to answer any questions. Representative Busey, just FYI. Other than that, thank you. I'll be closing later, but if members have any questions, we'll move to testimony. All right. Chair calls up Robert Green. You just pass if you want, but say hint. Right, got you here as Robert L. Green. You're on behalf of the Travis County Republican Party Election Integrity Committee and yourself, and you are for this bill. Is that correct?
That is correct, Chairman.
Please proceed.
It's another situation where we train our election workers. We train, a lot of people do train watchers, although it's not necessarily a requirement under the law. Election judges should be trained on what is permissible under their law and what is not permissible under the law. I think that's important because
Mr. Green, this bill is about training county election officers, not election judges. Okay.
Oh, I'm sorry. Yeah, I meant to say election officers rather. The judges get trained and watchers sometimes get trained, but I believe that it's important that election officials receive training too into the law and what they can do and what they can't do. Any questions? I'll be happy to answer.
Thank you, sir.
Thank you.
Representative Busey, anybody want to hear from the Secretary of State's office? Are you sure? Sure, okay. Is there anyone else who wishes to testify on, for, or against House Bill 4028? If not, I close on the bill. Is there objection to leaving the bill pending? No, if not, the bill is left pending. Thank you. Okay, this is going to be a fun one. Members, we're going to move on to House Bill 4044. It's another bill by myself. And so now the chair is going to explain the bill. Thank you, Vice Chair Gonzalez, members, for allowing me to talk about this bill to you guys. House Bill 4044 is a simple bill. It says that if a registrar fails to timely perform a duty imposed on the registrar under Subchapter B of Chapter 16 of Election Code, the Texas Secretary of State may withhold funds administered and distributed by the Texas Secretary of State. If there are any questions from members, or if not, I'll be closing after going to testimony. Members, are there any questions? Okay. Hearing none, we're going to proceed to testimony. Chair calls up David Weinberg.
Hello, David Weinberg here on behalf of the Brennan Center for Justice, opposed to House Bill 4044. Chairman, members, Briscoes, thank you for the opportunity to testify here today. House Bill 4044 seeks to hold a daunting specter above county voter registrars, threatening to withhold state funding if those registrars do not purge voters fast enough to the liking of the Secretary of State. These strong-arm tactics are not going to produce the results Texans deserve. Canceling voter registration is a job that should be done with great care and diligence. Voter registrars should not feel pressured to do this swiftly and cut corners. The right to vote is one of the most important civic responsibilities we are granted as Americans. We do not want county voter registrars removing legitimate voters from the rolls because they are worried that if they do not do it expediently, they may face budget cuts. There's also a counterintuitive logic to this bill. It's difficult to see how depriving county registrars of funds will enable them to perform their duties, including maintaining voter rolls. Moreover, county voter registrars are left playing a guessing game on how quickly they must comply with the Secretary of State or losing funding. We owe it to these public servants to not put them in this tenuous position with such an important responsibility for Texas voters and our democracy. And the last thing I'll say is, again, we heard testimony from James Slattery earlier today from the Texas Civil Rights Project. We have a little bit of a troubled history here in Texas in the last 10 years with voter purges in terms of ones that happened in 2012 and in 2019. So bills that sort of push people into directions of trying to purge rolls quickly is maybe something we should shy away from at this time. Thank you.
Members, any questions for this witness? Hearing none. The chair recognizes Representative Clardy.
Thank you, Mr. Weinberg, for your testimony, but you would agree that it's an appropriate goal for the state or the various elections officials, the registrars, to try to maintain as current and as correct of a roll of registered voters, wouldn't you?
Absolutely.
Yeah, I think that's something we should all strive for. I share some of the concerns you have as far as introducing criminal penalties and such, but at the end of the day, you know, I think it's something we have seen. There have also been historic examples in the state. I think Starr County, most notably, where the rolls just weren't ever being purged, and there were more people on the voter registration rolls than there were actually people eligible to be registered to vote. And so, you know, it seems to me that that's the intention of this bill, and I think, again, I think we should focus on that goal.
I would agree with you, sir. I mean, I guess just I think in terms of how do we solve this problem, I think, you know, county election officials have a very hard and complicated job, and sort of putting them on the clock to make sure that they do this correctly, or we're going to take funds away from them is not the right approach.
But again, it does seem to be there needs to be some motivation, some incentive to have those voter registrars. This is, I would think, in the roles that they do, is a relatively thankless and unfun job, and probably gets neglected for that reason. But it's absolutely a necessity that we have both current and accurate voter rolls. So if you have other ideas of how better to accomplish that, you know, I think we are all open to whatever would work to solve this problem around the state.
All right, thank you.
Thanks, sir. The chair now calls Rose Clouston. All right, I get you. Rose Clouston, Voter Protection Director of the Texas Democratic Party. You're against this bill, is that correct?
That's correct, yes.
Please proceed.
So there's a number of problems with this bill, but the most egregious that I would call to your attention is what this would have done in 2019 when the Secretary of State's office sent erroneous citizenship information to our counties. And the only reason that tens of thousands of voters were not removed from the rolls was because they did not take immediate action. Because the counties saw the flaws with that data and did not remove those voters in the way that the Secretary of State asked them to, because they used their judgment that they are empowered to do as the tax assessor or as the election administrator of their county and understood the flaws with that process, they were able to prevent this from having a negative impact on their voters while that case was then being litigated by many organizations and eventually settled where many of those voters were not actually removed from the rolls or sent those notifications to be purged. And so because I think that's a very recent and very clear example of a situation in which those election officials would have been intimidated away from doing what is right for their voters and what they knew to be the appropriate way to go about that work if this funding was hanging over their heads. Additionally, as Mr. Weinberg stated, the word timely is not defined, and it is unclear as to, do I have to do this, 4:30 on a Friday, or if I wait until Monday, am I going to risk losing my funding? And there is also no due process or appeal outlined for the election official if they believe that the Secretary of State is being punitive against them or otherwise inappropriately using this provision to withhold their funding. And that is also an inappropriate use of that authority. There are, to Mr. Clardy's point, there are existing accountability measures in place for our election officials. If you are an appointed election administrator, you are accountable to your election commission that has elected members of it who can hold you accountable and fire you if you are not doing your job in the appropriate way that it should be done. Similarly, if you are an elected tax assessor, the people of your county can choose to vote you out if you do not do your job appropriately. So there are existing accountability measures for these officials if they don't handle these duties appropriately. We don't need to add the Secretary of State and withholding funding into the mix. Additionally, I know of one county that had no staff in their election administrator's department for a little while recently. The election administrator had left, their subordinate had also left, and they had no staff. So would they then be withheld funding for not having anyone to do the job for a little bit while they're then trying to hire, which obviously would impede their ability to do that?
Okay. Don't you think if a county was having an issue with the Secretary of State, they could probably bring an injunction, a TRO, a mandamus, a writ of prohibition, they could defend themselves legally?
I think that is an extreme burden to ask a county, especially our small rural counties, to take on simply to get what are often small and are essential funds that they are severely lacking in many cases.
Members, any questions? Thank you, Ms. Clifton. The chair calls up Cindy Phillips. Okay. Jen Ramos. The chair calls up Jen Ramos. Chair goes up Henry Bonner. Johanna McCrary. Come on. Okay. Chair goes up Ben Brown. Mr. Brown. Okay. Chair goes up Robert L. Green. All right, I got you. It's Robert L. Green, here on behalf of the Travis County Republican Party Election Integrity Committee and yourself, and it shows that you're for the bill. Is that correct?
That is correct.
Please proceed.
Chairman. The only issue that I have in this is that there's no definition for timely. I don't know if this means 3 business days, 7 business days, or what. It does place the burden on someone to define that term, and I would hope that might be. I don't know if there was a plan for a committee substitute or something like that, but I think this is part of the registrar's duty that he or she should be liable for any willful failure to carry out the prescribed duties. We need to remove the deceased. We need to remove the move-aways from the county. We need to remove possible felons that may be on there, and we need to remove people who are non-citizens because none of those people are eligible to vote in that county. So I think that it's once again, it's, you know, you've got to have some kind of a penalty for people who willfully violate the law. Any questions? I'll be happy to try and answer them.
Thank you, members. Any questions for Mr. Green? None? Thank you so much. Chair goes up. Keith Ingram.
Good afternoon. My name is Keith Ingram. I'm the Director of the Elections Division at the Texas Secretary of State, and I'm here on House Bill 4044.
Yeah. I have a question. Members, any questions for, the chair recognizes Vice Chair Gonzalez.
How would the Secretary of State's office determine if a county is being willfully neglectful?
So a companion to this was heard in the Senate, and what I testified to there is the same thing here, which is that what we can do is we can monitor the tasks that we've sent the county on their dashboard and the age of those tasks, and if they are longer than 30 days, that's when we would trigger this.
And so how many tasks or infractions would they have to violate within that time period for it to rise to the level to withhold those funds? One, like, would it be just like one failure to cancel one single voter registration card, or was it done within a certain amount of time? I mean, would that rise to the level of that?
Right. If a task aged longer than 30 days on their dashboard, we would cut off their funds for non-compliance. We do a version of this now for offline counties who don't batch process with us overnight. For whatever reason, they skip a night. We put them in non-compliance, and then they do sync with us the next night, and they're back in compliance, and they can access their funds. So it's not a permanent cutoff of funds under either Chapter 19 or the Help America Vote Act. It's just temporary until they get that situation resolved.
Do you have any examples that you can share with us that have happened, within the past year where this provision would have applied?
No, because we don't currently. I mean, we do, but we don't have a strict 30-day rule right now. But if we notice a county is letting their task go, we call them and find out what the situation is. Why are they not doing their work? Sometimes we find out they've been on vacation or whatever, but it's not an infrequent occurrence that we'll call a county and say, what's the deal? You're not working your task in a timely manner. And we especially tighten up on that immediately following a big general election like we had in 2020, because the big thing that happens after a big election like that is we do our suspense purge. So the people who have been on suspense for 2 federal elections, we're going to cancel those voters, and we need to make sure that all the information is as current as it can possibly be so that we don't accidentally purge a voter.
Okay. Would a county elections official refusal to send citizenship verification letters to voters who are flagged on the 2019 non-citizen list that your office sent, would that have constituted willful neglect under this provision?
I don't know about that, because the matches that we sent under the non-citizenship program were weak matches, and they do have a duty to investigate those. They don't necessarily have a duty to send a notice of examination. If after their investigation they determine that the person is a citizen, then they resolve the task. So there's not, all we're going to be looking at under this bill is whether the task is resolved in a timely manner or not.
So if you were to have determined that they didn't investigate into those, that list of people, that would have risen to the level of willful neglect.
If they didn't resolve the task within 30 days, then we would cut off their access to Chapter 19 money or HAVA money under this bill.
To have investigated every person on that list, right? You said they have a duty to investigate.
That's right.
So they would have had to have done the investigation within those 30 days, and if they didn't.
And it's my recollection that before that 30-day period expired, there was already a TRO in place statewide.
All right, thank you.
The chair recognizes Representative Schofield.
So, Mr. Ingram, I think I understood you to say that there are fairly regular instances now where your office has to contact a county because they're not in compliance.
They're not working their task in a timely manner. I agree with that. Yes, sir.
I mean, we've heard a lot of testimony about bills in search of a problem. This seems to be a problem that we're currently having. Let me ask you something about the timeliness in the bill. There's some talk about, what is a failure to timely perform, and you mentioned 30 days as sort of a default. But there are some statutory timeframes for things you're supposed to do within a certain number of days. Like when you get the numbers from the Bureau of Vital Statistics about deaths and all that, you have a certain number of days to do things. I would assume that would, a statutory deadline would also be something you would look at, I would think.
I agree. Yes, sir.
Thank you. I appreciate it.
All right. Thank you.
Mr. Ingram, would you say, I guess, the timeliness of this, does that affect the accuracy of our rolls and accuracy of our list?
It does. The more timely that ineligible voters are, if they're removed in a more timely fashion, the rolls are in better shape.
Okay. Thank you. The chair recognizes Representative Clardy.
Mr. Ingram, I think this bill attempts to address
I agree. I agree with you on that. This doesn't address the threshold issue of what puts a county in noncompliance.
Will the record reflect that Representative Fierro is now present? Let the record turn the mic on. Let the record reflect that Representative Fierro is now present. Members, any other questions for Mr. Ingram? All right. Thank you, Mr. Ingram.
Thank you.
Let's call. Is there anyone else who wishes to testify on, for, or against House Bill 4044? If not, I'll proceed to closing on the bill. Members, I think this is it's a good bill. Some may differ. I think there's got to be a way, though, to hold people responsible, as we've heard from the Secretary of State's office. Theoretically, would be implementing a 30-day timeline, so things would be untimely based on that 30-day timeline. And, the timeliness of the performance of their jobs affects the accuracy of our list, and it could possibly lead to people being placed on the suspense list improperly because the timing of these records being transferred to the Secretary of State's office. With that, I do close. Members, are there any questions? Thank you, members. If there's no objection, House Bill 4044 will be left pending. Is there objection? Hearing none, the bill is left pending. Okay, members, we're going to take up our last bills. So bills going to be 3645, 4028, 4044, 4323, 4322, 4364, 1987.
I'm sorry, Mr. Chairman, can you repeat that, please?
Yeah. House Bill 3645.
Is that written here or?
Whoever come by over to you. One moment. House Bill 3645 by Kane. Again, that's House Bill 3645 by Kane, House Bill 4028 by Kane, House Bill 4044 by Kane, House Bill 4322 by Jatan, House Bill 4364 by Jatan, House Bill 1987 by Vasut. members, at this time, the chair lays out as pending business House Bill 3645 by Representative Kane. Members, this is the bill we heard previously relating to the elements of illegal voting and clarifying a criminal offense. Representative Jeton moves that House Bill 3645 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez. No. Beckley. No. Busey. No. Clardy. Aye. Fierro. No. Jeton.
Aye.
Schofield.
Aye.
Swanson.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out House Bill 4028 by Kane. Members, this is a bill we heard previously relating to training for county election officers. Representative Clardy moves that House Bill 4028 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey.
Yes.
Clardy.
Aye.
Fierro.
No.
Jeton.
Aye.
Schofield.
Aye.
Swanson.
There being 6 ayes, 2 nays, the motion prevails.
3 nays.
No.
Backup members, there being 6 ayes, 3 nays, the motion prevails. As correction, it's 6 ayes, 3 nays. The chair lays out as pending business House Bill 4044 by Kane. Members, this is the bill we just heard relating to the registrar's failure to cancel a voter registration under applicable law. Representative Jeton moves that House Bill 4044 without amendment be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey.
No.
Clardy.
Aye.
Fierro.
No.
Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 4 nays, the motion prevails. The chair now lays out House Bill 4322 by Jeton. Members, this is the bill we previously heard relating to the location of a polling place. The chair moves that House Bill 4322 without amendment be reported favorably to the full House. The recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey.
No.
Clardy.
Aye.
Fierro.
No.
Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 4 nays, the motion prevails. The chair now lays out House Bill 4364 by Jeton. Members of the bill we previously heard relating to poll watchers and creating a criminal offense. Representative Schofield moves that House Bill 4364 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
No.
Beckley.
No.
Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes, 4 nays, the motion prevails. The chair now lays out House Bill 1987 by Representative Assoot. Members of the bill we previously heard relating to the eligibility requirements to hold a political party office. Representative Schofield moves that House Bill 1987 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane.
Aye.
Vice Chair Gonzalez.
Nay.
Beckley.
No.
Busey.
No.
Clardy.
Aye.
Fierro. Jeton.
Aye.
Schofield.
Aye.
Swanson.
Aye.
There being 5 ayes and 4 nays, the motion prevails. That's the end of the agenda, correct?
Yep.
Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the House Committee on Elections stands adjourned, subject to the call of the chair.